Okay, let me just let me go get the judge and we'll get started. There we go. I can smell it from my desk. I'll bet you that's what it is. Smells good though.
What's that?
Somebody's cologne. I thought the judge was sprucing up.
Why I'm flattered.
Oh my gosh. It's Wednesday.
All right, good morning. This is People versus Adam McCreary, and we're here on two different files. There's file 214841FY, the use of cocaine conviction, and file 4190 of 2020, which is the assault charge and conviction. So Mr. Seeger is here on the assault case, and Mr. Graff on the use of cocaine charge. Have you both had an opportunity to review the pre-sentence investigation reports with your clients? Mr. Graff?
Yes, Your Honor, we have.
Okay, Mr. Seeger?
Yes, sir.
All right. Any changes to the report in file 4841, Mr. Graff?
No, Your Honor, just things that we can adjust during allocution. Thank you.
Okay. How about you, Mr. Seeger?
No material additions, corrections, or deletions, Your Honor.
All right. Thank you. All right. And I guess I should make sure, Mr. McCreary, you're able to hear okay, aren't you?
Yes, sir, Your Honor.
Okay. Very good. All right. So why don't we start with the assault case?
Your Honor,
Mr.
and I have no objection to starting with the assault case, but I was wondering, just because the recommendations are maybe a little bit different from each other, I was wondering if you could maybe handle Mr. Graff's file first, and then I can make my own determination
about the recommendation from you, or?
Yes, Your Honor. Just the recommendation between the two reports may be a little bit different from the other. So I was trying to determine what the court was maybe going to do in your file, or Mr. Graff's file, I should say.
Okay, well, I guess I don't see the point in that, so I'm going to go ahead and we're going to start with the assault case anyway. So what would you like to say on behalf of Mr. McCreary?
Your Honor, this was a very unfortunate incident, and I wish it never would have happened. I think Mr. McCreary feels the same way, that looking back in hindsight, that if he could have avoided this situation, he would have. Had we proceeded to trial, this would have been a case of alleged mutual combat. There was some recordings wherein it's alleged that one of the complaining witnesses essentially invited him over to his home to get into a physical altercation. He subsequently went there. They had an argument. There was a physical altercation. I think somewhere in the middle, the father ended up trying to get in between, and he subsequently was struck. Nonetheless, Your Honor, in speaking with Mr. McCreary, he acknowledges what he did was wrong. He shouldn't have gone over there. There shouldn't have been a physical altercation, and he wishes that he could take it back. Looking forward, Your Honor, it's my understanding that he recently gained custody of his child. He's been separated from that child for a period of time. He's trying to make right with his family. He wants to pay off his court costs and fines. He wants to pay his debt for his actions. He wants to move forward. He currently has employment available to him. He's doing the best he can to make things right. He's extremely remorseful for his actions. He's hopeful that the court would give him an opportunity to be placed on probation, primarily because he now has some stability that he previously did not, including employment. He now has an opportunity to be with his child, which previously he did not. He recognizes that, whatever it is that the court does, he's going to have to deal with it based on his own decisions in the past. But he's finally gotten to a point in life where he feels a little bit more comfortable, a little bit more safe. He's making much better decisions. He's in an entirely different place now than he was previously. And he's hopeful that the court will take into consideration that he's not picked anything else up during the course of his bond. He's done relatively well. He's staying out of trouble. He thinks that he could successfully complete probation if given that opportunity. And so I would just ask the court to consider that as a potential option. I understand that the recommendation does not contemplate probation, but maybe this is a good case to monitor him one way or another, which he has indicated that he would successfully complete his probation if given that opportunity, given that he has so many different reasons to complete it if ever he struggled in the past.
All right. Well, part of the problem here is Mr. McCreary didn't show up for the PSI appointment on June 1st. And so I don't have any information about employment. I do see that he used to work at least at Accurate Outdoors Landscaping and had his own handyman business at one time, but is he currently employed?
Yes, I work for Accurate Outdoor, Your Honor.
Oh, you are working there. Okay, you're working full time?
Yeah, and whenever I can get side work with my business, I'll do a weekend or two.
Okay. Well, Mr. Seeger, the other thing is when I read the victim impact statement, it seems that I'm missing a lot of information here about exactly what happened. I have no idea what the fight was about. The fact that there are two victims and there's only mention of the one victim in the PSI. Mr. Garza claims that this was an assault on a wheelchair-bound disabled person. Can you help me with that? If that's not accurate, Mr. Garza says that the defendant assaulted him in front of his 12 and 14-year-old kids while he's in a wheelchair and disabled. I wish the report would have said that, but
Your Honor, if I
is that just not true at all?
Yes, Your Honor, that's not true. I have video of him and his two sons, and I'm not trying to make it sound like I'm excusing what I've done, but I have video of him on his feet punching me, pulling me onto his porch with his two sons. And obviously, when the police came there, he wasn't in a wheelchair, and he wasn't even involved at first, Your Honor. I was working with his sons, and they didn't show up for work on a job I needed them to. And I said, let's throw hands. And we went to go throw hands, and he got involved and, punched me, and I reacted. I shouldn't have even been there, but that's the truth of it. And I've already sent my attorney the video a couple times. There was, said it was grainy or something like that, but I would be more than happy to see it. And it shows it pretty clearly.
Well, I was hoping to hear a little bit from Mr. Seeger. I guess that's accurate. He was in a wheelchair then, so I don't know how you have to assault someone that's in a wheelchair. You can
No, he
easily
was-
get away, but
He was not in a wheelchair, Your Honor.
who's not in a wheelchair.
No, I have.
Okay, there's also talk of the wheelchair ramp having been damaged and unusable now. And Mr. Garza claims that was somehow a result of this incident. But again, I don't have a lot of information about that, and there's no restitution that's in the recommendations. And so do you know any more about that, Mr. Seeger?
I don't, Your Honor. I really can't comment on that. And what Mr. McCreary is saying about like having a video is accurate. He did send me a video where there was a physical altercation between two people. I don't specifically recall if the third person was involved or was in that particular piece of the video, but he did send me a video. And again, one of the defenses would have been that it was mutual combat, but he accepts his responsibility for what had happened. I guess, like, it's helpful to review a police report, I suppose, but just like anything else, Your Honor, I'm sure that there are parts of the police report that are entirely accurate. I'm sure that there are parts of the police report that are maybe not entirely accurate, as it's a secondhand report. But the way that Mr. McCreary had previously described it was that it was a case of mutual combat that got out of control, more or less.
Okay. Well, thank you. Was there anything else you wanted to say, Mr. McCreary, about
Yes,
that
sir.
case?
In regards to the deck, and the video also, which I can send to my attorneys again, it shows them pulling me onto their porch, like literally. So, if it got damaged I'm 300 pounds, but so if it got damaged, it was from them pulling me over. I'm not quite sure how that didn't get into a report. But I'd be more than happy to send you that video.
Okay. Thank you. All right. We're going to go to the other file here. And so, Mr. Graff, what would you like to say on behalf of Mr. McCreary?
Thank you, Your Honor. I'll try not to repeat some of the information Mr. Seeger conveyed to the court, but as the court is now aware, Mr. McCreary has a good job at Acura Outdoor, and he has a side business. I think things are finally starting to come together professionally for him and in his personal life. As I understand things, I've known Mr. McCreary for a couple of years now, and unfortunately, you look at the long list of a criminal history for a 32-year-old man, and I represent him on a number of those cases. He's now telling me he's in a position with his child, which he's been working very hard, that he has, I think, 15 Sundays of time with his daughter, Annabelle. And I think that if he makes those 15 Sundays, then he can transition to having more time. And that's not something that I think was on the radar previously when dealing with the other cases. Of note, in representing Mr. McCreary in prior cases, there really wasn't a whole lot of contact. I'd send him things. I couldn't get a hold of him. It was difficult. And I have noticed a difference in this case. He's read the mail I've sent him. I call him. He answers the phone. He talks to me. He's responsive. And so I have seen a little bit of maturity in that regard. In the specifics for this case, I saw some maturity in Mr. McCreary. Unfortunately, he had some warrants out, and he wasn't dealing with those properly. When the police came to arrest him, as he's being walked back to the police car, he says, "I have cocaine in my pocket." That's probably not something he would have done in his prior instances. He probably would have hoped they didn't find it and or probably got a smuggling charge. And so he was upfront and cooperative in that regard. Your Honor, when we take a look at the assessment, he had quite a tumultuous upbringing. Not easy for anyone. And I think some of the problems that he's dealing with may be as a result of some of that trauma. I think we take a look at the history. Not only did he share the history of trauma, but he said he went to counseling and he found that helpful. And so I think when we take a look here, we have an individual with a number of drug crimes. We have a number of assaultive crimes, and we have someone who may be finally, hopefully turning the corner and getting to the age where they're over some of these things. There is some help that can be provided through probation. Obviously, Mr. McCreary doesn't have a strong history of abidance by any of the probationary terms that have been invoked upon him previously. But those were a couple of years ago. And Mr. McCreary's indicated to me that he thinks he can make it this time. He thinks the services would be helpful. I think they would be important, not only helping him overcome some of this underlying trauma and some of these issues, but the court could keep their thumb on him, make sure that he's doing the right thing, make sure that he's appearing for court dates, make sure he's appearing for counseling, make sure he's drug testing, make sure he's alcohol testing, make sure that he's not assaulting anybody, as well as it keeps him on track, not only with keeping his job, but also getting his daughter back. And so I think we could make this a success story if Mr. McCreary would give me opportunity and he takes advantage of that opportunity and shows the court. We understand the recommendations. We understand there are consequences for his actions. Obviously, his prior record is catching up to him, and that may be part of the reason for the recommendations. But I would hate to see Mr. McCreary lose his job and lose the progress he's made professionally as well as with his daughter when there are potential services that could be provided. And so we're asking the court, although against the recommendation, to give him that opportunity, knowing full well that if he messes up on probation, he most likely will get that 93 days and possibly more. And so he knows, understanding that if he asks for probation and gets it, he could get more of a sentence than what's originally recommended. But that would be the position we take today, Your Honor. Thank you.
Okay, thank you. All right, well, this is sentencing on the defendant's conviction of first of all, 2 counts, a single count of assault and battery. This was reduced from 2 counts of aggravated assault. The facts that are fairly sketchy are that the defendant was arguing with Derek Boyle, and the defendant apparently lunged at the victim and kept trying to punch him, and eventually just attacked the victim. It might have begun as a verbal argument, but that doesn't excuse the assault, which apparently the defendant started, and maybe the fight continued. But according to Mr. Garza, one of the victims, he was wheelchair bound, and all I have is the defendant's statements about what happened here and Mr. Garza's take on it. And he said this assault occurred in front of his kids. He was very upset about that. And apparently he's disabled. He's in a wheelchair, and he says his wheelchair ramp was damaged as a result. So in that case, it should also be noted that the defendant failed to appear, first of all, for his substance assessment, later did appear for that. So we do have a substance assessment, but failed to appear for his PSI appointment on June 1st. The defendant comes to the court with a long prior criminal history. This is his 3rd assault. There was a 2006 in Grand Rapids, and then 2019, for which he got 45 days in jail in this county. And there are also other offenses that involve assaultive or malicious conduct, the attempted malicious use of telecommunication device in 2018. There's also the attempted concealed weapons charge, for which the defendant was given the benefit of a Holmes sentence in 2011, and then numerous drug convictions. Now, those are all marijuana, 3 marijuana convictions, but I would note that in at least 2 of those cases, the probation was revoked. That's in 2016 and 2018. And so when probation has been tried, it's been unsuccessful at least twice. Now, I got to assume the Holmes was successful out of Detroit.
Yes, sir.
That's going back to 2011. On the bright side, Mr. McCreary is 32 years old. He apparently does have a GED and 2 years of college at Wayne State University. He's is employed at Accurate Outdoors Landscaping for a substantial period of time. He, from what I could tell from the substance use assessment, at least 2 years. And one time he owned his own handyman business. So he's got some skills and as Mr. Graff indicated, he comes from a very unstable background, and he's had a lot of hard knocks before getting to this position. But frankly, and I should also note that Mr. Garza also indicated his nose was broken during the incident. That's why he went to the ER. That's why this was originally charged as an aggravated assault. At least on Mr. Garza, there's no information for me to know why there was an injury to Mr. Boyle. What that injury was, I have no information about that at all. Be nice to know, but I think all of that is beside the point. I think the most important thing here is that the defendant continues to commit assaultive acts, despite the fact that this court has put him in jail in the past for similar conduct, 45 days in 2019. This is at least a dozen criminal offenses. This did involve, from what I can tell, an aggravated assault because Mr. Garza says his nose was broken. And the fact that he assaulted a disabled person in a wheelchair in front of his two kids, I think all of that warrants the recommendation that is being made. And I don't think probation is called for in this case. The defendant has obviously had the benefit of several probations, and I'm not sure what else could be done, at least in this particular case. So the sentence is the 93 days of jail with a credit for time served. That's 6 days with good time.
Your Honor, may I speak before you issue sentence?
Probably looking at 9 days less than that. Who is this?
Adam McCreary, sir.
Oh, I'm sorry. That's Mr. McCreary. Sorry, I was looking down at my papers. No, this is the time for sentencing at this point. You and your attorneys have had a chance to speak, and now it's the court's turn to render sentence. So, let's see. So that's file 204190. There's also a fine of $100 cost. I'm going to make that $100. I'm not sure why the $800. There's no supervision in this case. 75 Crime Victims Fund judicial system fee is $50, and you'll need to repay the cost of your court-appointed attorney. That's $250. In addition, I'm going to leave restitution open, and Ms. Odom, if you could just alert the prosecutor's office that that'll be open for 60 days based on Mr. Garza's statement that there was property damage. In file 4841FY1, defendant is convicted of use of cocaine. The facts are that when he was arrested, I assume on this offense, let's see, is it almost a year later? Yeah, well, September to February. Okay, so 5 or 6 months later, on this offense, he was found at the sale and bar and arrested, admitted he had cocaine in his pocket. And I do give him credit for admitting that rather than the officers having to discover it at the jail, which they inevitably would have done anyway. But the defendant has failed to appear for urine screens on at least 1, 2, 3, 4, 5 dates, tested positive for THC and amphetamines in violation of his bond on 4/20, and then THC on 5/8. For that reason and the defendant's failure to appear for his PSI and the fact that the probation was revoked in some of these prior cases, there's no recommendation for probation in that file. The substance analysis, in addition to pointing out that the defendant does have a lot, again, of adverse childhood experiences from his past. He's been in and out of foster care 13 times, I think it said. Nevertheless, the conclusion there, based on the defendant's reporting, is that there's no substance use disorder. Or, let me see. Nevertheless, the report is recommending abstinence. Make sure I've got that right. Abstinence from alcohol and other drugs only. And if he tests positive, then it's recommended that he be further evaluated. So, given the fact that essentially there's been no attempt to follow the testing, I guess I could go one way or another. I could skip probation, or I could follow the recommendations in the assessment and place the defendant on a probation and see if he is able to comply. What I would say is that the fact he tested positive for amphetamines on April 20th, is refusing to test on several other dates and tested positive for THC on 5/8, shows exactly what the assessors were looking for: the inability to follow an abstinence centered bond. And so that would tend to indicate that there is a substance use disorder. And so this is what I'm going to do. I'm going to place the defendant on probation for 1 year. There's going to be a fine of $100, costs are $400, Crime Victims Fund $75, judicial system fee is $50. There is a $650 court-appointed attorney fee because this was a felony case to start out. I'm not going to impose any additional jail time at this time, but I am going to impose conditions of probation once he's released on the assault case to assure abstinence. And so that will be during the term of probation, you're not to consume or possess any alcohol, no mind or mood altering substances, including marijuana, no illegal drugs, obviously, and no non-prescribed medications. If you do have a prescription, you need to provide that to the probation office within 48 hours of obtaining that. You'll be tested twice per month drug screens and 8 times per month alcohol testing. There will also be discretionary testing for both drugs and alcohol. The rather than determine what the counseling or other treatment options might be, the defendant is to report all of the missed tests, the failed to appears, the positive test to Catholic Human Services and complete a new evaluation and follow all new recommendations that they may have based upon those testing results. The defendant is not to behave in a violent, threatening, or intimidating manner toward anyone. He's not to possess any weapons or have them at his home. That includes firearms. And he is not to, he's to behave in a respectful manner towards all treatment providers and the probation staff.
Can I look at this? Not to interrupt others. Alcohol, Mr. Resident.
Thank you.
You're welcome.
The defendant is not to enter bars or casinos. Let's see, and not to operate a motor vehicle with any of those substances I described earlier present in his system, and not to operate a vehicle without a valid license, registration, and insurance, and report any contacts with law enforcement to your probation officer. The probation in this case, I believe, is warranted by the fact this was actually the facts make out a felony, possession of cocaine. The fact the defendant has 4 prior controlled substance convictions on his record, as well as another 6 offenses, criminal convictions. And I didn't see any indication that he's received help for substance abuse in the past. And again, his testing results indicate that he does have a substance use problem, I'll say, but Catholic Human Services will be better able to address that. So that is the sentence of the court. Let's see, is there anything else for you, Mr. Seeger?
He's gone, Josh.
Okay. Yeah.
Oh, there he is.
Okay, Mr. Graff, anything else for you?
Your Honor, I guess just to comply with the new statute, informing Mr. McCreary that he does have the right to request early discharge from probation after halfway.
Okay, so Mr. McCreary, you do have the right to request early discharge at the halfway mark if you're doing well on probation. So that would be 6 months in. Let's see. You know, I'm going to, based on that, I'm going to make the probation 15 months since he's going to be in jail the next 3 months. And that would drastically alter the length of the probation. So we'll make the probation 15 months. All right, we're all set for today, except Mr. McCreary, you do need to turn yourself in, let's see, by 4 p.m. this afternoon to the Grand Traverse County Jail.
Your Honor, is there any way I can do it Sunday afternoon so I can explain to my daughter what's going to happen?
Well, I'll tell you what, since this offense occurred way back in 2020, I don't think there's any urgency to the jail time. It will give you a chance to talk to your employer as well.
Thank
And
you.
let them know what's going on. So I will make that one concession for you, Mr. McCreary. You can turn yourself in Sunday we'll go with the same time, 4 p.m. Your jail time won't start until that date, obviously. And anyhow, that's it. Thank you, and feel free to sign off.
Thank you, Your Honor.
Can I speak with you separately?
Was there something else, Mr.?
Yeah, I was trying to speak with Mr. Graff personally.
Oh, you'll have to call him at this point. He's already left the meeting. All right, thank you. Okay, let's go to people versus Milo. And that is file 203377SM. Mr. Fisher is here on the defendant's behalf, and this is the date set for sentencing on defendant's convictions of embezzlement. Well, it's just the embezzlement, I'm sorry. The use of controlled substance was dismissed. So, Mr. Fisher, have you had an opportunity to review the pre-sentence investigation report with your client?
I have.
Is it accurate and complete?
Yes,
All right.
and it is accurate, with one exception, and I don't know whether this is the time to address it, but I just note that Officer Stanichuk noted that I was not court appointed, but under recommendations imposed a $250 court appointed attorney fee. And so I
got it. Yeah. Okay. All
I'd
right,
like to
thank
address
you.
the court after Mr. Milo, Your Honor.
After Mr. Milo? Mr. Fisher, can you still hear me? You're frozen. I'm sorry, I didn't catch that. You want to address the court after Mr. Milo?
Yes, to address one.
Okay, Mr. Fisher, let me stop you right there. There's something going on with your connection. I can only hear about 1/4 of what you're saying. So I don't know if you want to try to fix that. Well, I don't know if you want to log off and log back in or something, or start it out real good.
Yeah, why don't I do that? Because earlier I was having trouble hearing you.
Yeah, what? Go ahead. Okay, we'll wait for you. All right. Give me a chance to fix
I'll
my
log
chair.
out and come back.
All of a sudden, it started sinking.
That's happened to me too in my chair. And you end up with your chin on your desk.
Hopefully it doesn't do it again.
Had no
When I
idea what to
realized
do.
what happened, I started laughing.
Did you see it?
I heard you. I was like, oh no, that's terrible.
How's this,
Okay,
Your
I
Honor?
see you. Much better. Okay. So what I heard last was, did you want Mr. Milo to address the court first?
I did.
Okay, so Mr. Milo, what would you like to say to me before I sentence you?
Okay, can you hear me okay? Am I broken up?
Yes, I hear you just fine.
Okay, I just prepared a statement for the court I'd like to read, if that's okay.
Okay.
Sorry,
Go
I have
ahead.
glasses to read the statement. First of all, I would like to apologize to the court, my former co-workers at Costco, my family, and myself for my despicable, horrid, atrocious, and uncharacteristic actions last April that led me to this point in my life. I committed a terrible decision that I must reflect on every single day and will for the rest of my life when I made that stupid decision to take that medication from the pharmacy and commit a crime last April. I was put on antidepressants and anti-anxiety medication of some kind by my primary care physician in 2005 and have been on them ever since. Never had I ever been to a psychiatrist or psychologist to address the underlying issue of my mental health until last May, when I started to see a psychologist up here in Traverse City by the name of Ashley Dunham. Ms. Dunham has literally and truly saved my life through biweekly, monthly, and frankly, anytime I need phone counseling. She has helped me understand the fact that I do suffer from mild depression and panic attacks, and it is okay to take these medications and seek the help of counseling and talk to my primary care physician about these issues in my life. Last February, when the pandemic really began to affect my daily life, I was working in the hearing department, and due to the pandemic, our department was shut down. I was subsequently moved into the pharmacy department because I had already been through HIPAA training and management thought it would be a good fit. Through the pandemic, I was drinking too much, lonely, and taking these medications and spiraling deeper into depression and anxiety. I had not been able to see my 6-year-old daughter or my mother, the two most important people in my life, for months on end. People around me were getting sick with COVID, and it seemed like the world was crumbling due to the pandemic. In April, I had decided to take myself off of all my medication cold turkey without speaking to my primary care physician, because for some reason I felt that this would make my life clearer and happier. The exact opposite happened. Then I got through horrendous withdrawal symptoms on multiple occasions. I was not thinking correctly and decided to take medication from the pharmacy, which led to me getting caught, resigning, and being charged with a crime. I know what I did was wrong, and for that I am deeply sorry for my terrible and uncharacteristic actions. Since last May, I have worked extremely hard to get my life back on track and address my mental health daily. I still go through counseling monthly or bi-weekly if necessary. I take my medication as prescribed by my physician. I have stopped drinking because it affects my meds. I have found a terrific new full-time job at Tustini's, where I am the warehouse and fulfillment manager, with great coworkers, and have a great support network of friends and family I speak to daily. I volunteer at the food rescue through Goodwill and have taken up meditation and writing to help my panic attacks. I still got to get on occasion. I am committed to living a clean life and helping my community in any way I can. I am truly am very sorry and ashamed of my actions last April, and am willing to prove to the court and to you, Judge Cooney, that I can be a responsible, a helpful person to the community, my family, my faith, and mostly myself. Thank you for your time, and God bless.
All right. Thank you, Mr. Milo.
Thank you.
Mr. Fisher, what would you like to say on behalf of Mr. Milo?
You able to hear me? Because the last portion of Mickey's presentation, it was a little bit garbled. Can you hear me okay now?
I'm hearing you just fine now, and Mr. Milo, you're able to hear okay?
Yeah. Did you hear what I had to say?
I heard every word very clearly, so okay. I'm not sure what's going on with Mr. Fisher's iPad there, but
okay.
But I did hear everything you just said, Mr. Fisher, fine.
I'm going to try joining on my...
Okay, that's fine, because you're probably going to want to, I know you're going to want to hear my sentence and whatever those conditions are, so.
I know conditions.
All right, can you hear me better now?
Yes, absolutely.
All right.
Whatever you did worked.
Well, I'm on my iPhone instead of my iPad now.
Okay.
I understand what Mickey said to you, Your Honor, and so I thought it was pretty compelling what he had to say, but I'd like to review a couple of things for the court as you consider the sentence that you're to impose today. From the moment that he was confronted by the people at Costco with respect to the theft of the drug, he admitted immediately The police report will verify what I'm saying in that regard. He did not take these pills so he could go out on the street and make some money. He took these pills because as he had stated, he went cold turkey and shouldn't have done that without the assistance of somebody in the medical field. Thereafter, he took it upon himself without any court involvement to correct the situation. And I don't think that happens that often. I mean, we're 14 months down the road roughly from the last time that he was employed by Costco, which I think was on April 30th, 2020. And he has taken, as I stated, taken it upon himself to make some corrections in his life. Since I've known him, which has been several years now because of some legal problems with the mother of his child, I do know that Mickey has battled alcohol, but in terms of being a straight shooter and a loving, caring kind of guy, he's it. The prosecutor and the probation department might say something like, well, he's lucky that he wasn't charged as a felon. I respectfully disagree that he's lucky. I think it was a charging decision that was the right one to be made. However, I would have gone one step further in charging and treated this more as a mental health issue than as a theft issue. And I was hoping that we would get 7411 treatment, but that wasn't to be. And so here we are. If the 10 days in jail is to be imposed, then maybe those in the jail system that think we need a new jail are right, because if this guy belongs in jail, there are a whole lot of others that belong there as well. Mickey's a stand-up guy. He's a hard-working guy. He's a good dad. And more importantly, is the fact that he has accepted full and complete responsibility before we get into the court system and you impose conditions of probation and that sort of thing. So based upon all of that, I would ask that you impose fines and costs. If you believe that probation is required to keep Mickey on the straight and narrow, then I guess we impose probation, though I don't think that's even necessary, because if he doesn't get it by now, then he's probably not going to get it. And he gets it. There's just no doubt in my mind that as we look at the parade of humankind that comes before the court, if there's one thing that stands out about Mickey Milo, it's the fact that he has accepted this responsibility and made some significant changes. So thank you for the opportunity to address the court, and turn it back to you, Your Honor.
All right. Thank you, Mr. Fisher. Right. This is sentencing on the defendant's conviction of embezzlement from an agent or trustee less than $200. What happened is, as has been explained already, the defendant had been taken off some medications by his doctor. He was working at the Costco pharmacy at the time, and because of being taken off those addictive medications, at least one of them, he began to take that substance Xanax from the pharmacy. And I don't know if it was because he didn't want anyone knowing he was taking it. He's certainly not someone that couldn't have afforded to purchase Xanax, but he stole the Xanax instead from his employer. And that was because he was having these withdrawal symptoms.
Can I make a statement, sir?
Yeah, do I have part of that wrong, Mr.
Yeah, yeah. I was not taken off medication. I had myself thrown my medication away to go cold turkey. Nobody took me off the medication. I was prescribed that legally.
Okay, thank you for saying that.
I disposed of
and okay, and the report does say that it was your decision to stop taking them. So, okay, thank you for correcting me on that.
Yeah, sure.
So anyway, the defendant said he took the pills twice, probably took about 10 pills each time. He was caught on video, so there wasn't much question about what happened. Nevertheless, he was charged originally with use of a controlled substance and embezzlement under 200. And the defendant comes to the court with one prior conviction, that was impaired driving back in 2015 out of Oakland County. It says he did 1 year of probation, and apparently that was successful. To the defendant's credit, he is obviously very remorseful, thoughtful in his comments about what happened, and sorry he did it, sorry for what the impact on his employers and so forth. And he was cooperative with his employer and the police, and took responsibility for what happened, and in fact took it upon himself to get enrolled in counseling with a psychologist after the incident, and has attended on a regular basis up to this point. He's also talked to his doctor about what happened and how to deal with all that. And also, to the defendant's credit, he comes to the court with he's well educated, has a bachelor's degree, well employed at Fustini's, apparently is a volunteer in the community, helping to raise a 7-year-old daughter, and apparently pays his child support, because if he didn't, it would certainly say that on the report. So that's all very important, and to the defendant's credit. So then the question becomes what to do in this case. As Mr. Fisher pointed out, the conduct in this case could have been charged as a felony. And you know, it's up to the prosecutor's office how to decide to charge these cases. Sometimes it's frustrating for this court. The degree of difference in one person's conduct and another, and what gets charged, what the conviction is, and then what the outcome is going to be. I have a person in my drug treatment court, which Mr. Fisher is familiar with, who pretty much did the same thing here, stealing from an employer. Now, in that case, it was a healthcare worker, but they got held to the felony. First time conviction, no prior record. That person is in a 3-year probationary program to try to correct a controlled substance problem. And I don't disagree with the charging decision in this case, or the fact that it was pled to the embezzlement. But I'll just say, since Mr. Fisher expressed a little frustration with the system, I'll express my own, that it sure puts me in a difficult situation when I'm trying to decide what's fair and what's not. So anyhow, what I do agree with Mr. Fisher is that simply putting the defendant in jail for 10 days would probably be the easiest thing for Mr. Milo. You sit there, you read some books, and it's pretty humiliating and all of that. But at the same time, I don't see any rehabilitative purpose in that. The defendant lost a good job as a result of this. That's a collateral consequence that he's got to live with. Luckily, he landed on his feet. working at Steeny's, and that's going well. And I'm glad to hear that, because I'm glad that this problem with Xanax did not result in an unmanageable crisis for Mr. Milo, because that would be bad for the community in general. So what I am going to do, however, is I'm going to place the defendant on a term of probation that is going to be for 1 year. The reasons for that are that there is a prior substance conviction. That's the impaired driving. They may seem unrelated, but they both involve substances, one alcohol, the other Xanax. And the thing about this case is there's been no testing that's been required. And so the substance use assessment, although it indicates that the defendant does not meet criteria for substance use disorder, it does suggest remain abstinent from alcohol and other drugs and have this monitored by the court. And that's because all of this information is self-reported. And given how frank and I think honest Mr. Milo's been this morning, I'm not questioning whether what he told the assessors is accurate, but sometimes I think people do have a tendency to perhaps withhold, and for all kinds of reasons. They don't want to admit they have a problem. So hopefully it's not any more than what's stated in the substance use assessment. But I think the abstinence part of that recommendation is a good one. And that would be the primary purpose of this probation, is to make sure that there's not more going on here than what meets the eye. And that the defendant continues under court order with his psychologist, and making sure he's checking in with his doctor to make sure everything's going well. I want to see the defendant continue on this course. So the fine is going to be $100, cost $400, Crime Victims Fund $75, judicial system fee is $50. As far as restitution goes, Mr. Fisher, I'm surprised there's no restitution at all. I'm sure it would be a small amount for what might be 20 Xanax pills, but I guess I'll just leave that open for 30 days. If Costco or the prosecutor wants to pursue restitution, they can. The terms of the probation are going to be that the defendant is not to consume or possess alcohol, no mind or mood altering substances. That includes marijuana, no illegal drugs, and no non-prescribed medications. If you do have a prescription, and you do, we all know, you're to take that according to your doctor's directions, provide a copy of the prescription to the probation officer within 48 hours of obtaining it. And let's see, you are to not behave in a violent, threatening, intimidating, or harassing manner toward anyone. Not that I would expect that from you, Mr. Milo. And be respectful to all court employees and care providers. You're to continue counseling with your current psychologist, and follow all recommendations of the counselor. So that means if she thinks you need to continue monthly counseling for another 3 months or 6 months or indefinitely, that's what you need to do. You need to, again, follow all doctor's orders. There will be monitoring for both drugs and alcohol. I'm going to keep it somewhat modest, but there will be a benchmark test today. That needs to be done between 6 and 8:30 p.m. at the New Directions on Logan's Landing. The Drug testing will be once per month. Unless that benchmark shows positive, then I would go twice a month. And alcohol screening will be, we'll make it 4 times per month. And your probation officer will have the discretion to reduce that testing at some point if you seem to be doing well. I am going to impose 3 days of community service work. Let's see. I think that will do it. So, Mr. Fisher, anything else for you?
The contact number for the probation department that he should use. I know that Ms. Stanichuk may not be available this week, so.
Okay. Yep, that's you call the Traverse City Probation Office these days, and it's 231-922-6899.
Okay, you have, we'll make sure that he has that number, Your Honor. Well, thank you very much. Appreciate it.
Okay, thank you, and good luck to you, Mr. Milo. All right, Mr. Birdsley is here. Mr. Birdsley, I just want to confirm you do not have an attorney, correct?
Yes, Your Honor.
And that's your own choice. I want to give you the opportunity again. If you want to consult with an attorney before sentencing, I would give you that opportunity.
Okay, Your Honor. I understand, Your Honor.
Okay, and you want to waive that right again?
Yes, Your Honor. You can hear me okay?
Okay. Yes, I'm hearing you just fine.
Okay.
All right, we're here for sentencing then on defendant's conviction of retail fraud 3rd degree. And that is file 215035SM. Let's see. Have you had an opportunity to review the pre-sentence investigation report, Mr. Birdsley?
Yes, Your Honor, I have.
Okay. Are there any corrections or additions you'd like to see made to that report?
Not that stands out to me. I thought she summed it up pretty well. All right.
Okay. All right. And so what would you like to say to me before I sentence you?
I accept full responsibility, Your Honor. I've also thought long and hard about, what exactly I did. I understand that this is the court's time. This is Bernard's time. This is everybody else's time that should not be wasted. I coach football, varsity football out here in Frankfurt. And I have 2 boys under the age of 3. I have a wife who works really hard. And I'm trying to work really hard. I'm taking my builder's tests as we speak, or I'm in the course, pre-licensing course. There's just no excuse to steal, Your Honor. It just doesn't matter how hard life gets. It doesn't matter. There's just no excuse. I realize that with having a previous, things on my record, I have no more chances. And I just want to make it abundantly clear to the court that I will do whatever is necessary to prove. And that's kind of why I'm here without a lawyer. It was just because I just want to make this easier on everybody. I'm a good person. I'm a good dad. And I just want to keep grinding and do it the right way. I think that should sum it up, sir.
All right. When you were on probation for the embezzlement back in 2019, what sort of conditions were there with your probation, and were you successful?
I was unsuccessful, sir, because I did not complete my community service. At the time, I didn't realize, I had to get the court that I was in trouble with to contact the city, which was Frankfurt. So I was in trouble in Shiawassee County, and they were supposed to contact my county in Benzie, was supposed to contact Frankfurt to confirm the community service, which never happened. Because I built a pavilion for the START program, which I didn't get paid for and was technically volunteer service. But that's neither here nor there. The rest of it was, I think, 4 months, 6 months probation and a couple fines. which I did pay. But this time, I fully intend to do whatever is necessary, like community service. I've already spoken with the city superintendent, Josh Mills at Frankfurt, see what I could do to help out around the city. So.
Okay. All right. Well, thank you. Okay, this is sentencing on defendant's conviction of retail fraud, 3rd degree. And the facts are the defendant was at the Menards store and had picked out some things that he wanted, didn't have enough money to pay for them, and ended up shoving them in his coat pocket, walked out of the store. He was quickly stopped by an employee, and the defendant dropped the items and took off. However, they were able to catch up to him later. The defendant had actually removed the items from their packaging, so it wasn't possible for those to be resold. The amount stolen was $57.61. The defendant comes to the court at the age of 28 with a prior record of three priors. The most concerning of those was in 2019 out of Flint. That's the embezzlement less than $200. It's significant, of course, because it shows a pattern of theft. And ordinarily on a retail fraud 3rd degree, I wouldn't be thinking jail time or possibly not even a probation. In fact, that's a presumption. But in this case, the defendant does have three prior convictions, including a theft offense fairly recently in 2019.
Your Honor.
And Mr. Birdsley, at this point, well, go ahead.
I was just going to, I'm sorry. I apologize for interrupting.
Oh, okay. I thought you wanted to add something.
That I got sentenced in 2019. I believe the case took place in 2016.
Oh, it was 3 years old.
Yes, because they put out a warrant and they were supposed to, because I cooperated, and they were supposed to let me know, and I don't know what happened. And then all of a sudden, I was pulled over a couple of years later, and that's when I found out I had the warrant. So what? I just, it wasn't just a couple of years ago. But just wanted to clarify.
Oh, it does say date of offense, March 2017. Does that sound right?
Yes, sir. Yes, Your Honor.
Okay. All right. So you would have been
pre having children. So I would have been 25, 20, 24.
Maybe 25. Yeah. So 24. All right. And that does make a difference. You've obviously, there's a big difference between 24 and 28 and having kids. So anyway, I'm glad you pointed that out. Nevertheless, there is this prior conviction for theft, and the defendant does, to his credit, appear to be remorseful for his conduct. He's apologetic about his behavior as it affects Menards and their employees, and let's see. The defendant also is well educated. He's got 2 years of college. He's employed at Classic Dock and Lift, and apparently also does some construction work as a contractor, and has 2 kids. Otherwise, seems to be a good citizen, except for these prior offenses in this incident. Says he also coaches football. So those are all good, positive things. So anyhow, I think what's being recommended here makes a lot of sense based on all the circumstances. So I am going to generally follow the recommendations of the probation office. The defendant will be placed on a probation. I'm going to make it for 1 year. However, you may petition the court to be released at the 6-month mark if you've met all the conditions of the probation at that point. It's not automatic. We'll review the case, however, if you petition for that. The reason for the longer probation is because of the prior theft conviction and the fact this is your 4th time in court. And frankly, we don't want to see you back, and hopefully the 1 year makes a difference. So fine is $75, cost $100, Crime Victims Fund $75, $50 judicial system fee, and there's a $57.61 restitution amount owed to Menards. During the term of probation, I'm not aware of any substance problem involved in this case. There was a prior marijuana conviction in 2015, but I'm not going to concern myself that occurred 6 years ago and is no longer a criminal offense, and doesn't indicate a pattern that would show a substance use disorder. The defendant is not to behave in a violent, threatening, intimidating, or harassing manner toward anyone. Be respectful of court employees and service or care providers. You're going to attend and cooperate in and complete the retail fraud class through the court. There will also be there will also be 3 days of community service work. And if that isn't done, now you know that you will get some jail time out of that. I'm not going to make any promises what that will be. But hopefully you can find something meaningful to do in your community.
Yes, sir.
Let's see. Other than that, you're to obey all court orders, including paying all the fines and costs. Notify your probation officer if you do have any contacts with law enforcement. And let's see. You do need to contact the probation office. There's a number listed on the pre-sentence report at the bottom there. And please do that after 1 o'clock today and before they close at 4 p.m. Okay?
Yes, Your Honor.
They will go over the conditions of probation in more detail with you, answer any questions you have. We're all set for today, unless there's anything else, Mr. Birchsley.
I appreciate it, Your Honor. I hope to not be back in this courtroom again either. So I'm going to just put in the work.
Okay, that would be ideal for me too. So, all right, thank you, and feel free to sign off at this time.
Okay.
Okay, let's see. Is Brandy Tokocheski present? Mr. Kane, have you had contact with your client?
Not since yesterday. We've traded a bunch of messages. And the last one I have from her was last night at 6:30, seeing if she could speak with me. I was not able to reach her this morning.
So she was aware of the hearing today and the
Yes,
time,
sir.
correct?
Yes, sir.
And did she express any concerns about being here?
I think that would get into attorney-client privileged information, Your Honor.
In the ROA, there's a urine screen on 5/27 that's positive for amphetamines, buprenorphine.
What date was that?
THC 5/27.
5/27. Were you aware of that, Mr. Kane?
I know she's had trouble with testing, Your Honor. I didn't know that specific date, but that doesn't surprise me.
And there's no show cause or anything yet for a
And it was
violation.
amphetamine and what else?
BUP, I would assume that's
Buprenorphine likely.
and THC, and
Had obtained information from Ms. Tokarczewski indicating that she was following up on that and it was going to be dealt with at sentencing today. That's why there
it's
was.
514 and 522. I'm sorry, the entry was made on 5/27, so it's 514. And then again on 5/22 positive, and the THC actually went up from 80 to 103.
All right. Well, the fact she was aware of the hearing today and there's no explanation for her absence, and the fact that she's not complying with the bond conditions all give me concern, and so I'm tempted to issue a bench warrant. Mr. Kane,
If she
what's
were
your response?
if she were contacting me or responding to my contact attempts with her today, Your Honor, I might be able to give you a reason not to do that, but I can't come up with one without her help. So my preference obviously would be to show cause her so that she can show up on her own. But I have, other than my preference, I don't have a basis to ask for that.
Okay. All right. Well, I am going to revoke bond at this time. We'll reschedule this once she's been arrested, and I guess that's it, unless there's anything else. Mr. Kane?
No, nothing further from the defense, Your Honor. Thank you.
Okay, thank you. Okay, before we go to Mr. Quintana's case, we're going to take maybe about a 5-minute break here, okay? Mr. Graff, do you need to speak with Mr. Quintana at all?
I don't believe so. Do you need to speak to Mr. Quintana? I guess if we get a breakout room, Your Honor, might as well utilize the time. So if we could, that would be appreciated.
Okay.
Thank you.
Thank you.
Yeah. All right, we'll be in recess for 5 minutes or so.
Deputies hopped on too, so. We're just up there, I swear.
That's okay. We know you're seeing things. Okay.
Okay, I see Mr. Kane is back here. And have you had some success getting Miss Tokarczewski on the line, perhaps?
I have, Your Honor. I spoke with her a minute or two ago. Sent her the information she needed to log into Zoom. And she was supposed to do that. I don't know that she has. There was an unidentified phone, but it looks like that's a felony.
Okay.
Jameson. So let me follow up with her. I'm sorry to take the court's time. I'm sorry.
Okay, I'm going to go on to Mr. Graff's case while you do that. So, okay, so this is People versus Danny Quintana, and that is file 214997SM. Mr. Graff is here on behalf of Mr. Quintana, and this is the date set for a plea. I know you've had an opportunity to have some discussion this morning with Mr. Quintana, and is that what he still wishes to do, is enter a plea?
Yes, Your Honor. The prosecutor offered to dismiss the original charge if he would enter a plea to an amended charge of drunken disorder. He'd like to accept that offer and tender a plea to the court today.
Okay. So, Mr. Quintana, is that your understanding of the plea offer as well?
Yes, Your Honor.
Has anything else been offered to you to get you to plead guilty other than dismissal of the original charge? Or have you been threatened, forced, or okay? Have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, Your Honor.
All right. Do you understand that by pleading guilty, you will have a conviction for disorderly person, and that carries a maximum penalty of up to 90 days in jail?
Yes, Your Honor.
Has Mr. Graff answered all your questions?
Yes, Your Honor.
To your satisfaction? Okay.
Very professional, Your Honor.
Thank you. I'm glad to hear that. So I need to go over your trial rights with you, make sure you understand all those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand all of those rights?
Yes, Your Honor.
Okay, you also have the right to have the witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights?
Yes, Your Honor.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand those rights?
Yes, Your Honor.
All right. And finally, by pleading guilty, you give up the right to appeal that you'd have if you went to trial, and any appeal would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear your case. Do you understand that?
Yes, I understand, Your Honor.
And keeping in mind all those trial rights that you'd be giving up by pleading guilty, is that what you want to do?
Yes, Your Honor.
All right. So according to the complaint, on March 20th, you were at a location 1492 US 31 North. And that's in East Bay Township and Grand Traverse County. And you had some contact with police at that point. Is that all true?
Yes, Your Honor.
Were you intoxicated?
Yes, Your Honor.
Why were the police called to that location in the first place?
When I walked outside, I believe my wife and another female were in a fight at the time, and I broke up the fight.
Okay. Did you call the police then, or did someone else?
No, I think the other residents outside did, Your Honor.
Ah, okay. Now, I assume the basis for the factual basis for the plea is the resisting officers. Is that correct, Mr. Graff?
Kind of, Your Honor. The gist is, and the court will see from the facts, when the police arrived and broke everyone apart, Mr. Quintana didn't comply with their commands to continue to yell and egg on some of the other individuals to engage. And so not only did he not cooperate with the police, he also was loud and boisterous and created a scene himself.
Okay. Would you agree that your conduct, because of being intoxicated, disturbed the peace of your neighbors?
Yes, Your Honor.
Okay. And people in other public places on the road or otherwise, you agree?
Yes, Your Honor.
Okay. All right. Then to the added count then of disorderly person drunk, how do you plead?
I plead guilty, Your Honor.
All right. I'll accept your plea. Find it's voluntary, accurate, and understanding. And let's see. The original charge will be dismissed. Is there a prior criminal history, Mr. Graff?
There is, Your Honor.
I think I'm going to refer this for a pre-sentence investigation report, so I know a little bit more about the incident before sentencing. So we'll go ahead and do that, and sentencing will be on what date, Ms. Odom?
July 9th at 9:30, if that
Is that
works.
going to work, Mr. Graff?
That might be cutting a little tight, Your Honor. I have to be in circuit court at 9:45.
Okay, we'll pick something else or a different time.
Okay, hang on. We could do 8:30 that day if you'd like.
Sure, I can do 8:30.
All right, so 8:30 on the 9th of July, you said?
Yeah.
Okay, and prior to that time, sir, you need to contact our probation office after 1 o'clock today, and they want to find out your side of the story here, get more information about you, and I'm going to give you a number to call. Do you have a pen handy?
Yes, Your Honor. 1 second. Let's set you down for a second.
Are you
Take your time.
ordering an assessment?
Okay, what is it?
SIN assessment for a disorderly person?
That's probably a good idea here.
Okay.
Okay, so the number for the probation department is 231-922-68. Yeah, 922-6899.
Okay. 231-922-6899.
Yes, and I'm going to leave it up to the probation officer whether to get an assessment done or not, given that there was obviously alcohol involved. So we're all set for today then. Please call again after 1 o'clock this afternoon, but before they close at 4. We're all set. Feel free to sign off at this time.
Your Honor, if I may ask one question regarding the assessment, if one is deemed appropriate, would it be acceptable? It's my understanding Mr. Quintana is engaging in services with the Bay Mills tribe, where he's receiving counseling and in some type of IOP program. And so if there is an assessment that they've conducted, would that be acceptable to the court if the probation department requested one?
Yes, it would, as long as it's recent enough that it would be helpful. So, okay.
Thank you very much.
How about this? If there is some assessment, I want him to provide that anyway to the probation office, so they're aware of where he's at and what services he's receiving right now.
Perfect. Thank you, Your
And
Honor.
I have a question. So if it's not done and he needs to get one, is it okay to take it at the tribe too?
Yeah, that would be okay too.
Okay,
Get it
at
through
the
the
tribe.
tribe. It probably wouldn't cost him anything that way.
Okay.
So
I just got it done yesterday, Your Honor.
you did? Okay. Well, there's our answer. Okay, so I want you to make sure a copy of that gets to your probation officer, okay?
Yes,
So
sir.
change the dispo to say that he's
Yeah.
got an assessment through the tribe
Yep.
and
I'll provide.
he'll provide it to them. Okay,
Yes,
great.
sir.
All right, now we're all set unless there's anything else, Mr. Graff?
No, thank you very much.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah, okay, so we have Ms. Tokarczewski present now, and ma'am, are you able to hear me okay?
Yes, Your Honor.
Okay, Mr. Kane is here on the defendant's behalf, and this is the date set for sentencing. Before we get started, however, I'm going to note for the record, well, let me ask you this, Ms. Tokarczewski. You don't look so hot today. Are you able to understand what's going on?
Yes, sir. I set my alarm. I don't know why it didn't go off. I had my phone on silent, I think. I apologize greatly. I know this does not look good.
Your Honor, I've spoken with her. She's fine. She just woke up and she's scared because of the recommendation and she's been crying. So you're right. She's looked better, but it's not because of what you think. She's coherent. She understands what's going on. So.
Okay. You haven't had any substances this morning that would cause you to not be able to fully attend to this sentence?
Absolutely no. Absolutely no.
All right, then. Let's see, Mr. Kane, have you had an opportunity to speak with Ms. Tokarczewski about the pre-sentence report, and is it accurate and complete?
We have, Your Honor. I think that the only inaccurate portion that Ms. Tokarczewski objects to is the characterization of her addiction as a heroin addiction. I think it's more appropriately characterized as an opiate addiction. I think that she was prescribed Suboxone improperly and became addicted to it, and that it's less heroin and more opiates, Suboxone, whatnot. Other than that, there are no issues. That line is basically the date of the incident underneath the date, time, offense, the first sentence of the offense description.
Okay, so So you want to change that to indicate that she had an opiate addiction.
I do.
All right. Okay. Anything else, Mr. Kane?
As far as changes, no.
Okay. So go ahead with your allocution.
Thank you, Your Honor. I'm going to start with the substance use assessment, because quite frankly, it's a very useful tool for everybody. Ms. Tokarczewski suffers from a variety of substance use disorders, all up in the moderate range, but still in the moderate range. Opiates, amphetamines, and marijuana. That, at least in some sense, probably the marijuana, started back when she was early in her high school years, and she finished only the 9th grade in high school because she was getting in trouble for that. She was doing well in school, and she's smart. I know that from talking with her, but she hasn't followed through on much since. She managed to have to acquire an opiate addiction, and in large part, I think that some of the people she was hanging out with, largely her ex-boyfriend, haven't helped her in dealing with any of the things that she's got developed as a result of this, including this case. She caught this case when she was present at a search of a relative of her boyfriend's home. She was present with her boyfriend at that home. They searched the home. They found all kinds of drugs there, all kinds of felony charges against all kinds of people there. And they found a strip of Suboxone in her purse. And at one time she had been prescribed Suboxone, but her prescription had expired. So that is why we are here in front of you on a use of Suboxone charge. So that's why we're here. She has since reacquired her prescription for Suboxone, and I think that might explain some of the positive tests that you've had recently. Ms. Tokarczewski has explained to me that she did supply that information to the court. I think it was Lynn who prepared the PSIs, who she believes it was sent to, although this PSI appears to have been prepared by Ms. Stanichuk. So I don't know who it is.
It's Liz Stanichuk, yeah.
There's been big confusion with me as well as who I've been supposed to be in contact with over all of this.
So in any case, she has reacquired her prescription for the Suboxone and is on that. She has indicated to me that she was not taking this as seriously as she should have at the beginning and throughout a good part of it, largely because in the back of her mind is, I had a script, I've got a new script. Why should I care about this? Why should anybody care about this? And I think seeing your Ms. Stanichuk's recommendations has probably made her recognize exactly why it is she should treat it seriously, because the court's treating it seriously, and failure to comply with the court's directives in a serious matter means serious potential consequences. So, like I said earlier, she's scared. She's been crying. So that's part of why she has the appearance that she does. She's assured me that earlier we talked about the fact that there were some positive tests for amphetamines, positive tests for marijuana, positive tests for buprenorphine. Ms. Tokarczewski has assured me that if you were to test her today, you will find no methamphetamine. If you find marijuana, which she believes is probably likely, it will be at a lower amount than what you found before. And that if you find buprenorphine, you probably should, because now she has a prescription for it. But she understands that she can't be malingering any longer. She can't be ignoring the court's directives and basically just tripping her way through a case rather than doing the work on it. She is looking for work. She understands that that's going to be likely a requirement by the court and something she has to do anyway. And she had been in process of obtaining a GED. My understanding is she was close to finishing the math component of it. This started, and unidentified in the substance use assessment, or at least not identified as blatantly as I think it should be, is my belief that Ms. Tokarczewski suffers from fairly significant anxiety. And I don't know that she, up until recently, was getting adequate treatment for it. The doctor that she's going to for the MAT apparently also prescribed her some anti-anxiety and antidepressant medication. She doesn't recall exactly what it is. That has about less than a month old. My belief is that that should be coupled with some kind of counseling, because I think that what she's got, in addition to all this stuff, is some incredibly low self-esteem. And these factors are all working against her to not allow her to basically reach her full potential. The anxiety and the low self-esteem couple to basically not give her motivation to stay clean and pick the wrong fellas to be with who take her down the easy road. She's now living with her mom. She's cut ties with that guy. She's set herself up for some success. I think that she needs more help than what she thinks she probably needs. So the court may be, I believe, in the right ballpark if she's sentenced to some kind of intensive IOP or some kind of intensive work, something to keep her busy and something to keep her structured. My belief, Your Honor, is that I understand where Ms. Stanichuk is coming from with the 60 days jail. And my belief is that that will, in fact, while quite frankly justified, I think it will be counterproductive in this case. My belief is that that 60 days held in abeyance will have a far greater effect on getting Ms. Tokarczewski to fly right, check off the boxes that you assign her, and cement home the fact that the time to screw around is well in her past. She's not a kid anymore, and she has to take this seriously. One screw up and one failed box that is not checked means an automatic, at a minimum, 60 days. I think will go a lot further in getting her to comply with probation, putting her on the right path, and getting her to actually do something with her life rather than languish and wait for life to happen to her. So that would be my request, Your Honor. Scare her more than she's scared now, and let her know that 60 or 90 or 120 days held in abeyance is what she can expect if she misses a drug test, if she fails a drug test, if she doesn't get her GED, or if she doesn't get work, or if she doesn't go to AA as frequently as she's supposed to, or if she falsifies any records, or if she's hanging out with her deadbeat ex-boyfriend, or any of that stuff, and then she'll get it. But she needs somebody to parent her. And unfortunately, I think it's falling to you to do that, Judge. And my belief is that would be the best way to do it. So my request is that stick her on probation for a minimum of 365, hold that jail sentence in abeyance, and hold her feet to the fire because she needs it.
Okay, thank you, Mr. Kane. And I would like to hear from you, Ms. Tokarczewski. What would you like to say before I sentence you?
I'd like to say, I do realize and take accountability for the fact that I didn't take this as seriously as I should have to begin with. But I hope that it shows now that I've been trying to make an effort to show that I'm serious about changing, and I'm serious about getting my life together for not only me, but my daughter as well. And this is not the road I want to go down. I'm serious about getting better. I don't want to live this life. I don't want to be a criminal. I don't want to be in jail away from my daughter. Like, this isn't the kind of person I am truly at heart. And I hope that it has showed at least a little bit that I've been trying to put a foot forward. And I promise you, I will not regret it if I'm given grace and able to keep my freedom. It won't be a mistake. I will continue to move in the correct direction, and I will continue to grow and improve, and I will continue to stay clean. and do what is expected of me, because it's time to take responsibility and be a responsible adult. And I'm aware of that. And I do apologize.
Okay. Thank you.
Thank you.
So, Mr. Kane, I'm thinking about doing something maybe a little unusual here, and that would be to, Ms. Tokarczewski checks all the boxes for someone who should be in our drug treatment court.
I agree.
And I think I can do that without the prosecutor's consent, although I'm guessing that the prosecutor would probably agree with me if they reviewed the assessment. The advantage to the defendant in this case is that the testing is largely free. It's a lot of testing, but it's provided for by the drug court grant. And so that makes it a lot easier on her. But there's also requirements. You live in a sober environment. Where are you living right now, Ms. Tokarczewski?
I just packed all my stuff up and completely cut my boyfriend off. I was my ex-boyfriend now, I was kind of staying with him, but I packed all my stuff up and moved it all back to my mom's house. I got my car back and everything, and I've totally cut him off, and I've been at my mom's house for probably over a good week now, solid, with no contact with anyone except for my immediate family.
Yeah, what's your ex-boyfriend's name anyway?
His name is Joshua Ayers. He doesn't have any type of history or anything, but he was not a good influence on me when it came to the substance abuse. And I recognize that he was one of the main issues.
All right. And your daughter lives at home with your mother. She's the guardian, correct?
Yeah, correct. Though I am still very, very involved.
Okay. All right. Well, this is what I'm going to do. Ma'am, what I'm talking about is accepting you into our drug court program, which, there's a few requirements beyond what's being recommended here. You have to appear at drug court hearings and on a regular basis. There's more meeting with your probation officer, and there's more testing than is typically required, although I'm thinking I'd probably impose the same testing, but it'd be a lot cheaper for you in this case. What do you think of all that?
I think it sounds actually pretty good. It sounds like there'd be a lot of structure, a lot of constant, so I don't have the chance to stray off, Sounds like something intense is what I need.
Okay. Well, I agree. You're only 22 years old, and you've got a serious drug addiction issue. It's been going on since at least the 9th grade, it looks like, when you're getting kicked out of school for using marijuana. And things have just gone downhill from there. You're injecting heroin and using other drugs, and there's not much future for you on this path, and you know that, and your daughter's suffering as a result. So okay, back to sentencing then. The defendant is here on a conviction for use of a controlled substance, and the facts are, as Mr. Kane indicated, that when her boyfriend's cousin's house was raided, they found a strip of Suboxone in the defendant's possession. She was originally charged with possession of narcotic, a felony, and I'm maybe a little bit surprised that this wasn't a recommendation for drug court, given that the defendant has a prior record that includes shoplifting, receiving and concealing, B&E, legal entry, and there's a methamphetamine charge in 2019 for which the defendant was on probation for 2 years with a 7411, and probably received a lot of services then, but I don't believe they have a drug treatment court, however. And so the defendant has not been doing well with testing. She's tested positive a number of times for amphetamines, which I'm guessing is methamphetamine, as well as buprenorphine, for which she no longer has a prescription, and THC. And in fact, the last test we have was on May 27th that showed positive for amphetamine and buprenorphine.
Your Honor, if
Therefore, yeah, go ahead.
She had, at the time of the offense, she did not have a prescription. It's my understanding, although I haven't seen the script, my understanding is in the last month or so, she has reobtained her prescription to the MAT. So some of that testing may actually, well, hold on, Mr. My understanding is she does now have a prescription for it. Whether or not the court has that information is a question I don't have an answer to.
Yeah, I don't have that, but are they giving her this? Are they giving you the strips or the injection? Okay, so there's a really bad idea. You take a drug that's easily diverted, something that you've been convicted of a crime for, and you give them more strips instead of a 30-day injectable that you can't trade and you can't abuse.
Okay.
You know, it's like I'm fighting with the medical community.
That makes a lot of sense. That I would probably be more beneficial to the shot instead of getting more strips.
All right. Well, just makes the whole process that much harder.
I can definitely talk to my doctor about that.
Well, it might make sense for you to be on Suboxone, but certainly not in the manner it's being prescribed.
Right.
And on a misdemeanor probation, I could allow for that, but it would absolutely have to be the injectable form of Suboxone, the last 30 days. So, okay, so this is what I'm going to do. I'm going to place the defendant on a up to 2-year term of probation. And I'm going to, despite concerns I have about whether I'm following all the proper procedures, I'm going to place her in a drug court program.
That's a sample drug court sentencing dispo that's much different, and there's a second page that you would want to include.
Okay.
Okay, that will be helpful to you.
Okay, the costs and fees are going to be $1,000. And then there's the $650 court-appointed attorney fee. So it's just a straight-out $1,000. Let's see. You'll be starting. Most people have a 3-year probation. This is 2 years because you're starting out as a misdemeanor.
Okay.
I believe the statute has already been amended, so there is no license revocation. And let's see. But if I am required to revoke your license, it will be for the first 30 days of this sentence. And that's because you are going to go to jail. It's not going to be the 60 days. It's going to be 30 days with credit for time served. That's 0 days. But with good time, you're looking at about 25 days in jail. The reason for that is you have been unsuccessful in complying with these conditions. Okay, Mr. Tokarczewski, listen. You've been testing positive on a regular basis for amphetamines and buprenorphine that was not prescribed. And I'm not sure why you would be prescribed Suboxone if you're taking methamphetamine. You should be tested by a physician before being prescribed Suboxone to see whether you are on other substances or not, because this is just Anyway,
Please give me a chance.
so
Please give me the
no,
chance to show you guys.
this is your chance. This is your chance to go from being completely dependent on narcotic drugs to kicking that, okay? And you need to do it for yourself and your daughter. But the first 25 days is going to be in jail. And the reason for that is because I need to make sure when you come out, you're not going through withdrawal from this constant use of methamphetamine and other drugs. And methamphetamine is going to kill you at some point, or at least it's going to rot your teeth out. And
I probably,
if
you guys tested me today, it probably would not even be in my system. I have
Brandy.
not been using.
Brandy, you have to let the judge talk. Your time to talk is done.
Thank you, Mr. Kane. All right, so the conditions of the probation are going to be as follows. You're not to use or possess any alcohol, no illegal drugs, no non-prescribed medications. Frankly, they're not going to allow you to have Suboxone in the jail. You are only allowed to take the injectable form of Suboxone, and I'm going to talk to the drug court team about whether the continued use of Suboxone is a good idea in this program. You're not to use or possess any mind or mood-altering substances. You're not to use even over-the-counter medications without consent from the court. Let's see. There will be testing that will include 2 times per week drug screens. There'll be twice daily preliminary breath tests. You will be allowed to have a scram machine so that, and our grant covers the cost of that as well, or at least most of it, so that the cost of testing is not going to be your major concern anyway. So twice a week drug testing, twice daily preliminary breath tests. You are to not enter any establishment that serves alcohol by the glass unless permitted for work purposes. You're not to operate a motor vehicle with any of those substances that I just described in your system. You're not to operate without a valid license, insurance, and registration. And let's see, no violent, threatening, intimidating, or harassing behavior toward anyone. Be respectful of court employees and care providers. You are to attend 90 12-step program meetings once you're released. That's in the first 90 days. It'll be followed by 4 12-step program meetings per week with written verification monthly to the court. That sounds like a lot, but the purpose of that is to get you involved very quickly in the NA community so that you are you have people that you know and you can reach out to that are in a similar situation, and they can help you through this. You're to obtain a 12-step program sponsor within the first 90 days. There will be discretionary testing for drugs and alcohol as well. There will be, you're also to be released from jail if a treatment facility is recommended, and it's not in the pre-sentence report, the substance use assessment. What's being recommended there is early recovery group. I would say at least intensive outpatient services, but your case will be referred to Northern Michigan Regional Entity to see whether inpatient treatment makes sense. Otherwise, you need to attend intensive outpatient therapy. That could be through ATS or Munson Behavioral Health. Let's see, you're to sign and abide by all conditions of the drug treatment court handbook. You're to live in a sober living environment. Your mom would have to agree to the no substances condition and to a search of the residence if that was felt necessary to make sure that you don't have any of those substances I described earlier in the home. Let's see. If a oh, and you must take all your medication as prescribed by a licensed physician and sign a medical release for both doctors and pharmacists to inform them that you are a recovering addict. And that way, that'll give them more guidance as far as how to deal with your medications. Okay, so first court review hearing will be scheduled once you have completed the jail sentence, as well as any treatment that might be required before you'd be able to attend. So, Ms. Tokarczewski, it would have been real easy to just put you in jail for a long time based on your record and everything that's been going on. It's not productive, however, in my opinion. You've got a substance use disorder. You need to deal with it. And this might seem like harsh punishment to you, but it's not intended to be punishment. It's intended to get you straightened out here, okay? So
When is she turning?
you don't have a choice. You need to take full advantage of the services that are being recommended. And I'm going to recommend that you also go through our trauma program. And Ms. Lako, your probation officer, who this case will be assigned to, will talk to you some more about that. Mr. Kane, there was something else?
Well, I wanted to ask if the court was going to have at least a mental health assessment. The trauma program will recommend it if it's necessary. So thank you for that. Is the court entertaining the thought of any kind of no contact orders based upon past?
Thank you for reminding me. No contact with Joshua Ayers. You're not to go within 500 yards of his residence or employment. And speaking of employment, as part of the drug court program, you will be required to seek out and gain full-time employment. And if you're not doing that, it will be a lot of community service work until you do gain full-time employment. Employment is part of keeping you busy, so you're staying out of trouble and also gaining back some self-respect through work and making money yourself and taking care of your daughter yourself. So that will be part of the program. And again, Ms. Lako will talk to you about all that. So as far as turning yourself in, I want you to report to the jail by 6 p.m. this evening. Okay, you will be on.
I have not gonna have no time to like get my stuff taken care of and everything.
All right. Well, you should have known based on the pre-sentence report that you were going to jail today. In fact, it recommended a lot more jail time than what I'm giving you. But you have until 6 p.m. tonight to get yourself turned in. Okay?
You wouldn't give me 24 hours?
No. That is the sentence of the court, and that's it for today. Please feel free to sign off at this time. Thank you, Mr. Kane.
Thank you, Your Honor.
Mr. Kane, can I speak with you after?
You can call me.
Okay, thank you. Bye-bye.
Okay, let's go on to People versus Jack Jameson. Mr. Jameson, can you hear me okay?
Yes, I can. Getting my video started here.
Okay. And is Mr. Pedersen present? Oh, it's Miss Ascione,
Yes, Your Honor.
you're filling in for Mr. Pedersen. Okay, so this is file 215171SD. Again, People versus Jack Jameson, and this is the date set for both a plea and a bond violation hearing. Let's see, with regard to the bond violation, let's take that up first. Ms. Odom, what is the bond violation, if you could state that?
Yeah, it
so that
was,
we're all on the same page.
It was on that, let me think, hang on.
I'm happy to also, he had one skip test on May 30th. He did not test within the testing window. And that the next day he went to, I believe the court also has record of this. I got it from his bond officer. He went to New Direction to do an ETG. And showed that there was nothing in his system, but he also had tested outside the window of the 9 p.m. on such date, but it was not recorded because it's outside the window, and it showed nothing in his system as well.
All right, so I take it he's admitting that he missed the testing window. How far outside of the window was that, Miss Ascione?
He had fallen asleep and his alarm didn't go off, and he believes that it was between 10 and 11 that he then tested. So about an hour and a half to 2 hours.
Okay. All right, well, he hasn't had any misses since then, Miss Odom.
I missed the dates that she gave. I apologize.
Yeah, it was May 30th.
Okay, so I have different things in here. So I do have a skip test on May 30th. Smart Share Detail Report. Okay, maybe it's between 529 to 641 missed test. Hang on. Maybe I'm wrong here. There was a dilute on 531. Was that mentioned?
So that was
no, it wasn't.
That was the ETG he had gone to New Direction to take to try to supplement the missed test. So he was not required to do that. He just voluntarily went to try to supplement, as I said. And I don't have any record of another skipped test other than the May 30th.
That is correct. It was a little bit hard to read in here, but that's correct. Just the 530 and then the dilute.
Okay. Well, based on the fact that the defendant did take the ETG on 531, apparently it was dilute, so I have some concerns about that because, one reason to test late would be to try to sober up. And when the ETG is dilute, that could possibly mean that the defendant was further trying to affect the results of the test, even though it was not a court-ordered test. So,
if I may, Your Honor, we also we also have tried to contact SmartCert to get record that he had tested within that hour and a half window afterward. We don't have the record of that yet, so I don't know if it would make sense to request an evidentiary hearing to give us time to, showing that he didn't have anything in his system an hour and a half later is different than the diluted test, the next day, I believe.
Okay, well, Mr. Jameson, that's the problem with late testing or skipping tests or dilute tests is we just don't know. I'd be guessing, and I think having a hearing would, again, just subject me to trying to determine, something that is probably unascertainable at this point, and that's whether you had used alcohol. But because you've been testing and everything's gone fine, except for that one day. I'm going to overlook that for purposes of the case. So we'll continue bond. So let's go to the plea. Is that what your client still wishes to do, Ms. Ascione?
Yes, Your Honor.
And is there a plea offer?
There was not one.
Okay, so Mr. Jameson, is that correct? You want to plead guilty as charged?
Yes, Your Honor.
Okay, and has anyone made any promises to you to get you to plead guilty that have not been disclosed on the record today, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, sir.
Okay, so it's your own free will to plead guilty at this time, correct?
Correct.
All right. Have Ms. Ascione and Mr. Pedersen answered all of your questions to your satisfaction?
Yep.
And do you understand that if for some reason you were no longer able to afford their services, the court would appoint an attorney for you at public expense?
Yes.
All right. Do you understand that by pleading guilty, you will have a conviction for operating while intoxicated, and that carries a maximum penalty of up to 93 days in jail?
Yes.
All right, I need to go over your trial rights with you and make sure you understand all those before I'm able to accept a plea, so please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand all those rights?
Yes, Your Honor.
In addition, you have the right to have the witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights?
Yes.
You also have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that?
Yes.
Finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial, and any appeal from your conviction or sentence would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear your appeal. Do you understand that?
Yes.
Okay, so keeping in mind all of those rights, is it your desire to waive all those rights in order to plead guilty?
Yes.
All right, so according to the complaint, it says that on let's see, April 25th, you were driving a car on Oak Terrace and or North Garfield roads in Garfield Township and Grand Traverse County when this incident occurred. Is that true?
Yes.
Were you stopped by the police?
No.
Was there an accident?
No.
Oh, what caught the police attention to investigate this?
I believe they were following me, and I had arrived home and went inside, and then I had a knock on my door 15 or 20 minutes later.
Okay. So they didn't pull you over, but they followed you to your house. Okay. And prior to driving that evening, had you consumed alcohol?
Yes.
And do you know was there a test given and what was the result?
I don't know the results of the test. It was a blood test, so I don't know.
Yeah, there was a warrant, Your Honor. He was taken a month and his blood was drawn, but a warrant for his blood, I'm sorry, but we have not seen the results of that. I'm not sure if they've been disclosed to the prosecutor or not.
Okay, well, let me ask you this then. Would you agree that due to your consumption of alcohol, you either had over a 0.08 blood alcohol concentration, or you were under the influence of alcohol, meaning that because of consuming alcohol, your ability to drive a vehicle in a normal manner was substantially lessened?
Yes.
Okay. All right then. Was there a preliminary breath test that was given?
There was not, I believe there was one once he arrived at the jail after having gone to Munson. I've not seen a result of that. He vaguely remembers taking it.
Okay. All right. Well, he has agreed that his ability to operate the motor vehicle was substantially lessened. So based on that, I will accept a plea if that's what you want to do, sir. So to the charge of operating while intoxicated, how do you plead?
Guilty.
All right, I will accept your plea. I find it voluntary, accurate, and understanding. The next step would be to set this for a pre-sentence investigation. And I do want to get a substance assessment as well.
Your Honor, he has actually last Thursday proactively went to an alcohol assessor. We do not have the results yet, but just so you're aware. Peter's
okay, so where did you get the assessment at, sir?
It was Peter Zutendak, and I spoke with him this morning, and he'll have the results for that on Monday for me.
Okay, well, what I need you to do is contact our probation office sometime between 1 and 4 o'clock this afternoon. The number is 922-6899. Let them know that you've already had a substance use evaluation done and that you will get the results to them. They'll set up a time to interview you about the offense, and you can give them your side of the story, and so to speak, and provide any other information that might be relevant to me when I sentence you, okay?
Okay.
Sentencing is going to be on what date, Ms. Odom?
I chose July 8th at 9, if that works.
Is that going to work for you, Ms. Ashion?
That does work, thank you.
Okay, so what, can you repeat that date and time again?
Yeah, July 8th at 9.
Okay, July 8th at 9 o'clock. We'll be back here. I don't know if we'll still be on Zoom. Make sure you pay attention to the notice you get in the mail. And let's see, is there anything else for you at this time, Ms. Ashion?
Nope, that would be all. Thank you.
Okay, and bond again is continued, and feel free to log off at this time.
Thank you.
All right, is Dustin Birch present? Dustin Birch.
10:30.
All right, so this is file 204099SM, People versus Dustin Birch. It was set for a plea this morning at 10:30. It's now 11:10 a.m. And Miss Odom, has this case been adjourned in the past?
I'm gonna look it up for you. Hang on here. Oh. Looks like he had been in the Kalkaska jail. I wonder if he's still there. Also email him. Let's see. Defendant in Kalkaska jail, remanded till plea. He's in the Kalkaska jail.
Okay, so we'll get a notice. Well, we'll reset the plea and make sure that the defendant is aware of that at the jail, and that the jail makes arrangements to have him available if he's still going to be there when we get to the plea. All right, so let's go on to Matthew Scott. Is Mr. Scott present? All right, no luck there either. So this is file 214869 ST People versus Matthew Scott. This was scheduled for a bond hearing this morning at 10:45 a.m. It's now 11:12 a.m. and Mr. Scott is not present. So what I'm going to do is revoke bond at this time. However, if the defendant posts $200.
So you want a $200 bond?
Yeah, $200 bond. We'll set the bond at that amount. So anyhow, now we're up to our preliminary examinations, and Mr. Atwood is our, I guess it's the preliminary examination here, just one. People versus Austin Phillips, file 214-52683-FY. And Mr. Phillips, are you able to hear okay?
Yes.
All right, Mr. Williams is here on the defendant's behalf, Mr. Atwood for the prosecutor. And this is the date for a preliminary examination. Mr. Williams, what does your client wish to do?
Your Honor, Mr. Phillips is going to plead guilty to one count of attempted flee and elude, a misdemeanor, and one count of domestic violence second, a one-year misdemeanor as well.
Okay, Mr. Atwood, is that a correct statement of the plea agreement?
It is, Your Honor.
All right, and most importantly, Mr. Phillips, is that your understanding of the plea agreement?
Yes, it is, Your Honor.
Okay, it's been stated that the original felony charge would be dismissed if you plead guilty to these two misdemeanors. Has anything else been promised to you other than that? Or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, Your Honor.
Right. Do you understand that by pleading guilty, you will have two convictions, one for attempted flee and elude a police officer, and the other for domestic violence second offense, and both of those carry a maximum penalty of up to 1 year in jail?
Yes, Your Honor.
Has Mr. Williams answered all your questions to your satisfaction?
Yes.
Do you understand that if you were no longer able to afford Mr. Williams services, that the court would appoint an attorney for you at public expense?
Yes.
I need to go over your trial rights with you and make sure you understand all those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand all of those rights?
Yes.
You also have the right to have the witnesses against you appear at trial, to cross-examine those witnesses, and to present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand all those rights?
Yes.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that right?
Yes.
And finally, by pleading guilty, you give up the right to appeal that you'd have if you went to trial. Any appeal in this case would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear an appeal of your conviction or sentence. Do you understand that?
Yes, Your Honor.
And knowing that you'll be giving up all of those rights by pleading guilty to the reduced charges, is that what you want to do?
Yes, Your Honor.
All right, then I'm going to turn to the complaint at this time, and I need to establish that there were, in fact, these two crimes that were committed. So, first of all, Is it true that on May 23rd of this year, you were at an address 1717 US 31, an apartment, and that you were with Marilee Godasak?
Yes.
Okay, and she was residing with you at the time, is that correct?
Yes.
And did you make an assault on Ms. Godasak?
Yes, Your Honor.
Okay, what did you do?
Your Honor, may I assist Mr. Phillips?
Sure, go ahead.
Mr. Phillips, you were in Grand Traverse County on or about that date, correct?
Yes.
And Ms. Godasak is also your grandmother, correct?
Yes.
And on that date, you became very agitated and angry, correct?
Yes.
And you yelled at her, you screamed at her, you got into her face, and you do not deny at some point pulling her.
Yes.
So there was a delay there. So just to be clear, you do not deny assaulting her, yelling at her, screaming at her in a very threatening and intimidating manner, and at some point you do not deny that you had pulled her hair, correct?
Correct. I do not deny.
Okay. And just he's, you know, just the hesitancy there and his lack of remorse or admission. He's was on a lot of he wasn't properly medicated, and he's been struggling with a lot of mental health issues that he's been addressing. So that there was some. I just don't want the court to take that the wrong way. But I think that would be, and you've been previously convicted of domestic assault, correct?
Correct.
Okay. Yeah, I think that would be sufficient for the domestic assault factual basis.
Okay, and the complaint says that prior conviction was February 20th, 2014, and also April 27th, 2017, correct?
Correct.
All right, and for at least one of those, were you represented by an attorney?
I believe so, yes.
Okay. So that would make this a second offense, domestic violence. So with regard to that charge itself, how do you plead?
Guilty, Your Honor.
All right, I'll accept that plea, find it's voluntary, accurate, and understanding. Now, it sounds like the police were called and Deputy Rosa responded. And were you trying to get away from Deputy Rosa's car?
For the attempted fleeing and eluding?
Yes.
Yes.
Okay, and you knew he was a police officer. He was driving a marked patrol car with its lights and sirens going, and you refused to pull your car over.
Yes.
Okay, and was that also in Grand Traverse County?
Yes.
All right, so then to the charge of attempted flee and elude a police officer, how do you plead?
Guilty.
All right, I will accept your plea on that charge as well. It's clear that your plea is voluntary, accurate, and understanding. The original charges of domestic violence, third offense, and the felony flee and elude will be dismissed at the time of your sentencing, and that will be on
July 8th at 9 if it works.
I can make that work.
Okay, so we'll be back here on July 8th at 9 a.m. And prior to that time, I'm going to need you to contact our probation office Mr. Phillips, and I'm going to give you a phone number for that. It's 231-922-6899. If you didn't get that, Mr. Williams will provide that to you. Oh,
Okay.
we lost Mr. Oh, he's still there. Okay.
Sorry.
All right. So sometime, I want you to call them sometime between 1 o'clock and 4 p.m. Is there any reason I should be concerned about getting a substance use assessment?
No.
Yeah.
Oh, hang on. I was actually asking the attorneys that question, Mr. Phillips.
So, Your Honor, I think that it would, in this particular case, his grandmother, who was the victim in this case, wrote a really thoughtful letter. I think that it would be helpful to do a substance abuse evaluation, and particularly since I think it's important to document the prescribed medications that he really should be on. And I think in this particular case, it probably is going to be helpful for him and helpful at sentencing. So I would say that this would be important.
Okay, so I will ask for a substance use assessment. And if you could make sure I get a copy of that letter from the grandmother. I don't know if it was her victim impact statement or not, but I'd like to know more about any mental health issues and any other information you think would be helpful to my sentencing determination, Mr. Williams.
Yeah, I'm going to get you that. And I also have a letter from the medical psychiatrist. I'll get that too. So I'll try to get incorporated into the PSI.
All right, thank you. Is there anything else we need to take up today, Mr. Atwood or Mr. Williams?
No, Your Honor, thank you.
All right.
Not that I'm
thank you. Okay, we're all set then for today. We'll see you back on the 8th for sentencing. Mr. Phillips, feel free to sign out at this time. Thank you.
Yeah, Your Honor, can I ask you a question? Not related to this case, just general question. If the court starts scheduling sentencing in person, if I get permission from my client and file that with the court.
Oh, Lord.
Mr. Williams, you're breaking up, so I can't hear you, but I think I know your question is, and that is if Mr. Phillips is willing to waive his right to be present in court, would I allow him to appear by Zoom? When we go back to in-person hearings, my intent is to have sentencings conducted in person. There are going to be a lot of hearings, I think, where we decide that Zoom is going to work. And I'm all in favor of moving pleas and some things like that to Zoom. But anyhow, for purposes of sentencing, it's going to be in person. Now, I don't know if we'll be at that point yet, but if there is a good reason other than it just makes it easier for everyone, then I would entertain a motion to have it conducted by Zoom, but I'd have to know what the reasons are for that are special to this case.
No, can you hear me now?
Yes.
My question is,
yep.
My client would be there in person. I would not, and I would file with the court his permission to allow me to appear via remotely, but he would be there present. And I'm just asking that question. I'm having some issues with my back. So traveling more than 30 minutes is becoming, I had back surgery like 6 years ago. So I'm dealing with that issue. So I'm just asking in the future, if it's an in-person sentencing, if the client agrees to it, if I could appear remotely, but the client would be there in person.
Okay, well, that's a little different. So I don't see why that wouldn't work. So yeah, if Mr. Phillips is willing to allow you to appear by video, that would be just fine with me. The limitations on that, Mr. Phillips, are that Mr. Williams wouldn't be right next to you where you could ask questions or whisper something to him. But generally, by the time of sentencing, the attorney has discussed everything and answered all your questions. And the court could possibly, well, I could have you make a phone call to Mr. Williams if you wanted to talk to him in private, even if you were here in person. So we could make that available to you as well if something came up and you really felt like you needed to ask him a question or get some advice before proceeding, okay? So sorry to hear about your back issues, Mr. Williams. That's always well, it's not a fun thing, I know. So anyhow, so if you get that waiver from your client, I'd be willing to allow that. And we're all set for today. Again, unless there's anything else, Mr. Williams.
No, thank you very much.
Okay, sure thing. Good luck with your back.
Thank you, Your Honor.
Yep, thank you. Okay.
Good morning. All right. It's a wrap.
It's a wrap.
1:30
Yeah.
Right now, 1:30's looking.
Speedy Gonzalez in the last.
Yeah,
half.
I haven't heard anything different about the 1:30. Is that in person or is it?
Yes.
It is, okay. So we will be wrapped up by 3:15, however, because I have a doctor's appointment I have to get to, so just so you're aware. And they said that they thought it wouldn't be a problem getting done by then, so.